Management of the corporate sector is a crucial part of the Australian legal system, and through development of our market and the means in which we do business, the law has been required to undergo constant evolution to keep in contact with such rapid development. The scope in which Australian lawmakers are able to operate in the corporate sector is established by the Australian Constitution, with the legislative authority of the corporate sector resting in the Corporations Act. The enforcement body to this is the Australian Securities and Investments Commission, with powers set out under the Australian Securities and Investment Commission Act. As it stands, legislation sets out 7 main business structures under which an individual or individuals trading under a company may operate. These include, but are not limited to, sole traders, partnerships, companies, proprietary limited companies, public companies, trusts, and associations. Each of these structures have significant benefits and significant challenges in their operation. In advising our client, it is vital to highlight both of these aspects of selecting a business structure with which said client may wish to proceed. A key aspect of any business is that of risk of liability. Clients wishing to set out a business plan must ask themselves, what am I prepared to lose as part of their project planning? In doing so, it becomes apparent how much separation the client wishes to have from their business assets and personal assets, and how much oversight the client is prepared to be exposed to. This gives advisors the opportunity to research and prepare management modelling proposals as we are today. In doing so, I'm aware that you may require me to understand these business models and the duties and functions applied and approved to each of them under law. Therefore, I've prepared a brief overview that I will use when in discussion with the client. So I will explain a sole trader. A sole trader is a business structure where the person trading is legally responsible for all aspects of the business. This is to mean that any loss incurred by the business is to be held by the sole person and cannot be shared with any other persons. Considered to be the most inexpensive and straightforward method of beginning a business, sole traders are able to employ staff and make decisions for their businesses by themselves. Minimal oversight is required by the officers of the Australian Securities and Investments Commission Act and the ATO, although sole traders are required to hold financial records up to 5 years and pay payroll tax for distribution of wages to anyone other than their business owner. Moving on to proprietary limited companies and the public companies. Companies, they are an entity separate from its shareholders. In English, the assets and liabilities of the company are separate from that of the people who own the company. In good times, it means the influx of dividends paid to the shareholders as prescribed by the constitution of the company. In bad times, this means that the shareholders won't have homes and other assets seized to pay debts incurred by the company. So for obvious reason, business owners are a big fan of this separation as it provides a sense of security in doing business. With such a structure, there are many benefits, but they are in turn managed by strict legislative requirements based on a number of differing factors. A proprietary limited company is limited to 50 non-employee shareholders. Aside from that, 50 all shareholders are to be in some respect employed by the company per Section 113 of the Corporations Act. Further to this, proprietary limited companies are not able to garner public funding and must have a minimum of 1 director being a resident in Australia. The public company is any company other than a proprietary limited company, and as a result is able to garner public funding through sale of shares. These companies must have a minimum of 3 directors, 2 of whom must reside in Australia. Public companies often sell shares on the Australian Stock Exchange, which is regulated in accordance with the provisions set by the government. Thirdly, the associations are often set up for sporting and recreational clubs and industry organisations, cultural and artistic institutions. Associations are usually set up as a non-for-profit organisation. If they've had a motive for profit, these institutions would not meet the criteria of associations as prescribed by legislation. In regards to partnerships, a partnership is where 2 or more people operate as a business as co-owners and share income. All co-owners, or otherwise known as partners, act on behalf of each other in the business. Like the sole trader structure, a partnership entity is not separate from its operators. I recognise that understanding the underlying responsibilities of these business frameworks is key to providing advice. By understanding these points, advisors can provide clear, concise, and relevant advice to those wishing to go out and start their own business. By giving them an understanding of the legal framework and the role it plays in the contemporary Australian market, business owners will be more confident in the value of the advisors they surround themselves with. In turn, by nurturing our client's business, we as practitioners may build a reputation that builds our own business. To determine the best business structure to propose to the client, it is important to determine the direction that the client wishes to steer the business. Is it a family business to support the family and be passed on to the next generation? Or is it a partnership of professionals seeking to stamp their own mark on creativity on the market? Or is it the beginning of a new era, a multinational company seeking to tackle the big market energy? Whatever it may be, only the client can tell us. When motive is established, framework is not a complex matter. The above examples align with the pre-described business models and the markets they trade in. Upon establishing the best fit, after explaining the operation of other business structures to ensure the client has a broad understanding of available options, detailed and personalized explanations of regulations and costs may begin. It is at this point that the conversation may dictate the question, but the key is to never assume that the client knows the answer to a question that they haven't yet been asked. Allowing the conversation to flow and having the client feel comfortable to make detailed inquiries about their business structure ensures that due diligence has been followed and the needs of the client are met. That being said, in my hand are a set of questions I have drafted as prompts for the conversation throughout the initial meeting with the client. Further to this, I will make it clear to the client that if at any stage I do not have an answer for a particular question readily available to me, research for the client will be undertaken.